count one vehicle. Other vehicles, additional vehicles, we may count as part of the determination, but those would be things like, depending on what they're used for. And so if you have like a one standard vehicle and then you also have another vehicle that has a handicapped equip or has some special uses, then that would also be exempt. So there are some additional exemptions even for the vehicles. Okay, talk for just a minute then, just go on to talk for a little bit more about some household rules and some general household rules. For the elderly and disabled programs, for the most part, when we're looking at eligibility, we're going to look at the adults. If they have an adult applicant, we're going to look at the individual and their spouse. If you're looking at the children, it's going to include their parents. But for HCBS and for long-term care, we have special rules for both of those. For HCBS and long-term care children, we only look at the applicant. We don't look at the child, or we don't look at the parents when we're determining eligibility for an HCBS child, and there is no resource limit for an HCBS child. For long-term care programs and for adults with a spouse, we apply the spousal impoverishment provisions, and that's what we're going to talk about right now, are those spousal impoverishment provisions. So spousal impoverishment has been around, I remember this date, September 30th of 1989, is when we first started using the spousal impoverishment federal rules. So they have been around for quite some time. And they are pretty much, believe it or not, pretty much the same as when they were back in 1989. So that's one thing that really hasn't changed very much. But spousal impoverishment applies to married couples. So you have to be married, and it can be common law. It can be common law married, but it has to be a marriage recognized in Kansas. So you do have to be married. Special resource and income rules essentially is what we're talking about for long-term care. So normally, and you probably know this, that if you're applying for long-term care, there's a resource or an asset limit. So when we were going through all of those countable resources before, the bank account, the stocks and bonds, the CDs, all of those things, normally you can only have up to $2,000 of resources and qualify for Medicaid. But with spousal impoverishment, you can actually have more. You can actually retain more resources above that $2,000 limit. And sometimes the community, we can even allocate income to that community spouse. The spousal impoverishment rules are actually twofold. There's an income side and a resource side. We're going to focus on the resource side, but we will touch on the income side too. So for spousal impoverishment to apply, you go to the next slide, you must be in long-term care for at least 30 consecutive days. And that's important because really with the next little bit is we talk about you only get one shot at spousal impoverishment. Well, unless you change spouses, but that's a different story. But one shot at spousal impoverishment, and it's the first time you're in long-term care for more than 30 consecutive days. So if you have one time, so what sometimes happens with our couples is that maybe they had an episode 2 years ago, and maybe mom was in, she started out in nursing, or she started out in the hospital, maybe went to rehab, then spent a little bit of time in the nursing home, but that was only temporary, so they really didn't think about it. And now 2 years later, she's in for a long-term stay. They don't think she's going to come back home. Well, we have to go back and look at that time from 2 years ago when she was in for 30 consecutive days. So that is really an important thing to remember, because a snapshot that we're going to talk about, it only happens once, and that's when that time happens, when it's 30 consecutive days. So what we'll do at that 30, as soon as we have somebody in there for 30 consecutive days, we'll ask them to help us take a snapshot of the assets that they owned on the date that that actually happened. So whether it's the date that arrangement began, or sometimes when you have somebody who just went to HCBS, and they haven't gone into any kind of institutional stay, that can be the date that they are actually screened eligible for HCBS, and they would have it. They're found in need of HCBS, and if there were a slot available, then they would have HCBS. We also look at that as meeting that criteria, just so we can do a spousal assessment. So this assessment, or this snapshot that we're taking, will basically go through and we'll count up all the non-exempt assets that that couple own. We'll add all of those assets together. And then what we do is we divide that in half. And that essentially creates a community spouse resource allowance. But you can see there are some minimums and some maximums there. So what we're going to do is we're going to take a look at how that plays out with some examples here in a bit. The community spouse resource allowance is the amount of assets that couple can actually keep. So when we went through, we counted all their assets, we divided it in half. Instead of saying you can keep 2,000, they can actually keep whatever this new community spouse resource allowance is, which for most people, it's half of the resource allowance. So it's kind of like a personalized resource allowance. You know, sometimes when we talk about spend down, we talk about that like it's your personalized deductible. Well, this is kind of like a personalized resource allowance. In addition to that, the long-term care spouse can also keep his original $2,000. So they get to keep the community spouse resource allowance plus the $2,000. The community spouse resource allowance remains in effect even if the spouse returns to the community. So like I was saying, you know, it's one time shot at it. The division of assets, you know, you'll hear this called the division of assets a lot. I put that up there just because there's not really a division that really takes place. There are some things that happen after the fact, but really you're not actually dividing up. You're not getting out a piece of paper and say, okay, you get the bank account, you get the car. It's not like a divorce or anything like that where we actually go through and say, you get this and you get that. It's what we're saying is, here are the couple's resources. The couple's resources are X. In order for that person to qualify for Medicaid, you have to spend down to this amount. So it's not really a division at all, even though a lot of times we'll call it a division of assets. So another important part is that there does have to be a transfer, that takes place after eligibility is complete and they've actually, you know, everything is spent down. Then they have 90 days to complete that transfer. So again, if there are any questions during this, just feel free to ask. So, okay, so let's look at some examples now, how this actually play out. So our first person that we're going to look at is Fred and Ethel. Okay, Ethel went into the nursing home on October 14th of 2014. Their total resources, and these are both Fred and Ethel's total resources at that time, were $100,000. So, you know what we said before, was we take their total resources and we divide in half. Half of 100 is 50. So, okay, so that means then that the community spouse resource allowance is $50,000. We get to add another $2,000 because the long-term care spouse always gets to keep $2,000. So that means that Fred and Ethel together, their assets have to be below $52,000 before they're eligible for Medicaid. Once they are below $52,000, then they can come back in and reapply. Well, they can actually reapply at any time, but they just wouldn't be eligible. But they would be eligible once those resources are below $52,000. And what we're going to ask them to do is show us a picture of Fred's resources, Ethel's resources, and their combined resources. So it doesn't matter whose name is on them. We're going to look at both, what Fred owns, what Ethel owns, and what Fred and Ethel own together. Just like before, it's whatever that couple has together. So show us what you have in the beginning and show us what you have now. And then we can talk about making transfers so that Ethel only ends up with $2,000 in her name. Okay? So if we look at another example, remember we said there were minimums. So this is an example where the minimum allowance would apply. So a couple who doesn't have $23,000 or doesn't have quite the resource level that Fred and Ethel did. In this case, it's Bert and Bertha. Bert is in the facility on March the 15th. Together, they have total resources of about $17,500. But we said before that the minimum was $23,000. So Bert and Bertha are already below the minimum. So that means that Bert qualifies right away. He could have $2,000 if he needed it, but they don't need to spend any assets down because they are already below the minimum. So even if we divided Bert's resources in half, it wouldn't matter. They're still eligible. So that's an example of where the minimum plays out. Now we're going to look at an example where the maximum plays out. And this is Jack and Jill. So Jack was screened eligible for HCBS on February the 10th of 2015. So remember we said before that for spousal assessment resource provisions, we would go ahead and do an assessment based upon the fact that, you know, Jack's screened eligible and said he would want HCBS, but there may not be a slot for him, and, you know, we have to go through all the other processes now. But Jack's screened eligible for HCBS. His total resources in February, their total resources were $400,000. So that month they had $400,000 in total resources. So we divide that in half. Half of that is $200,000, but there's a maximum. The maximum resource allowance is $119,220. So that would mean that because they're over that maximum, they could only have $119,220. So they would have to spend, plus it, Jack still gets a $2,000, so that couple would have to spend their assets down to $121,220 before they would be eligible, or before Jack would be eligible. So there are all different flavors of how this actually plays out that you can kind of see, hopefully you can kind of see, and that helps demonstrate what they would actually have and how the resource provisions of spousal play out. Now we're going to turn our attention to the income provisions for just a second. And we're going to talk about how you can reduce the total patient liability or client obligation. You know, normally you look at the person's income. When determining a client obligation or patient liability, we normally look at the client's income. They get to keep either $62 or $727, depending upon their living arrangement, and then the rest is the client obligation. Well, with spousal impoverishment, you can do what we call allocate to the community spouse or dependent family members if they live with the community spouse. So if you have somebody who's maybe a younger person with minor children, they would be dependent family members. You can allocate income to them and reduce that obligation. Or if you have other people who declare that they're dependent family members, and it can be, as long as they live with the community spouse, they can allocate money to them. So it could be an adult child if the client states that they're a dependent family member. It could even be a parent if somebody is a dependent family member. Maybe you were caring for your elderly parent before you went into the nursing home, or maybe the wife is caring for the elderly parent. They could be considered a dependent family member. So this is not, it's not narrowly defined. Let's just put it that way. There's a pretty broad range of what you can consider a dependent family member, but they have to be living with the community spouse. And there has to be a community spouse. So, you know, we do run into times with that dependent family member allowance where you have a child who's living, maybe there was a divorce before somebody went into the nursing home or went into HCBS, and there was a divorce, and there's still a child. That HCBS recipient still has a child, but because they're not living with a community spouse, you can't allocate to them under these provisions. So again, it's that living with the community spouse that's so important. But when you, to get down to the end, when you combine the income of the community spouse and the nursing home spouse is less than $1,992, the whole thing could be allocated to the community spouse. And so many times this will reduce the client obligation to zero. If you have somebody who's got a community spouse, you can usually reduce the client obligation to zero. For those with a little bit higher incomes, you can go up to $2,981 is the maximum that you can allocate. So they can have, you know, pretty high income. And then that dependent family member allowance is $664. So sometimes we'll see young folks who maybe the community spouse is still working, so her income might be above these limits, but maybe there's a dependent family member, a child, and they're not making up to $664, so you can allocate that to $664 to the dependent family member, even if you're not allocating to the community spouse. Okay? All right. I hope that made sense. So let's switch gears a little bit. And let's talk about good old transfer of property. Transfer of property is one of those always fun things to talk about. So basically transferring property for less than fair market value is what we're going to talk about, is anytime you've transferred property. And those transfers can be, and this is a pretty broad range. It's not just simply, you know, going back and trying to, you know, sneakily give something to somebody. It can be a wide range of things: selling property, gifting assets, adding owners or names to property, even refusing an inheritance. All of those are examples of what we call transfers of property. Basically, anytime you own something, you have an interest in something, and you take an action where you are reducing the value or your ownership interest, then that's considered a transfer of property and subject to penalty. And the penalties, and we'll talk about those in a bit, there are periods of time when you can't get Medicaid, you can't get long-term care Medicaid. And it can sometimes result in some real bad situations. But again, these are federal provisions for the most part. So basically, we're going to look at all transfers within the last 5 years. So if you've helped somebody fill out a long-term care application, there's that question. Have you sold, traded, or given away any bond of money, property, land value, etc. within the last 5 years? And that's why we ask that question, is because we need to find out if they have done any of these. And it includes all of those things above, even gifts, any of those things we are potentially considered transfers of property. And again, the result is that they can result in a period of ineligibility. When we actually look at what a transfer of property is and how much to penalize, the total value of the penalty is determined by taking the total value of the asset and then reducing it by the amount that they receive if they sold the property or gotten anything in return for the property, or any encumbrances, So those would be things like mortgages or notes or loans, things like that are held against the property. We do take that off of the value too when we're actually determining the total penalty. The penalty begins on the date the individual is otherwise eligible to receive Medicaid, and there are some methods to cure penalties, and we'll mention some of those here in a bit. So again, let's take a look at an example as a way to kind of see what a transfer property penalty looks like. So let's switch slides and let's go look at Mabel. Okay, so Mabel entered the nursing home in July of 2014. She applied for Medicaid in 2015, and she would otherwise be eligible for Medicaid, except that she transferred the property. What she did was she sold her home. The home was worth $100,000 in March of 2014 to her son for $20,000. Mabel thought she was doing a nice thing. Her son had helped her out. She wanted a home to stay in the family. So, she said she owed $10,000 on it. So she wanted to get enough to cover her mortgage to get out from under it. And, she needed a little bit of money to, buy a TV set before, she knew she was getting down in health, so she wanted to take care of a few things. So she thought she was doing something nice for her son. And in return, what happened is she ended up needing to go into the nursing home. And now she's out of money. So what happens is we're going to take a look at that total transfer, which was $100,000. We're going to reduce it by the amount that she received for the home, which was $20,000, less the amount that she owed on the home, which was $10,000. So the value of the total transfer was $70,000. So we're going to penalize her for a $70,000 transfer. The way we determine a transfer property penalty is we divide it by $172.32. That's not a number that came out of anywhere. That's the average cost. That's the average amount it costed to care for somebody per day in a nursing home. And that is where that amount comes from. And that's required by the feds. Again, another federal requirement. So the total penalty that Mabel is going to have is 406 days. So she has to go 406 days where she could have received Medicaid, and she's not going to be able to get it. So her penalty begins running on the date she would have otherwise qualified, which is February the 1st, and she's ineligible for Medicaid until in March of 2016. So, Mabel thought she was doing something nice for her son, and now she's kind of stuck in a bad situation. Now, I mentioned before there were cures for transfer penalties. The easiest thing to do is to give the property back. That is the easiest and quickest way to resolve it. Now sometimes, and what we sometimes see is that there is no more property to give back. Maybe instead of the house, Mabel gave her son cash, and maybe son thought, oh, trip to Vegas, and there is no more cash. So sometimes we have to get into what we call hardship provisions and things such as that. And those are all, if you have cases like that, we could certainly talk about some of that. But those get into some really bad situations. Legal recourse can also be another avenue that we sometimes see also. It's not always pleasant, but again, the easiest and best way is to avoid it. If you can't avoid it, then the best way is to just give the money back. So we do see people, so estate planners and things like that. There are all kinds of tricks out there to try and get around Medicaid, to try and maximize governmental assistance. There's a whole business around this, but it's not something that, the results can sometimes be detrimental to the beneficiary too. So, okay, I wanted to talk for a little bit too, just about some other resource provisions. We said we were going to talk for a minute about that, and I just wanted to point out some other things that we sometimes see related to resources in Medicaid. Life insurance. when you ask somebody about their resources, you don't normally think of life insurance as being a resource, and especially what we've seen over the years. A long time we've seen this, is that people don't think, oh, they think, well, that was for my burial. It's not really something that's countable. But unless they specifically turn it into a burial fund, it is a countable resource. And sometimes these things can add up. If they bought the policy when they were real young, or if daddy bought them the policy when they were a baby, and it's been accumulating over the years, these things can sometimes have some significant cash value in that somebody didn't know about. So we do count the cash value of life insurance, and sometimes it's a surprise, usually a good surprise. I mean, you have money you didn't know about, that's usually a good surprise. And it can sometimes cause some concern too, but it is an asset that we do count. The home and homestead, we want to talk for just a minute about that. I mentioned before that the home is usually exempt as long as the person is living in the home, or the spouse or another dependent is living in the home, or if the person intends to return home. So if a person is in a nursing home, as long as they say, I intend to return home, the home is exempt. There are no doctor statements required. You don't have to validate that medically to prove that yes, there's a possibility she can go home. The home is exempt. If none of those apply, then usually the home is a countable asset. Now there is something else that we started a few years ago, and that's something we call Medicaid liens. Where we are back, we did Medicaid liens many, many years ago. We stopped for a long time, and then a few years ago we started applying Medicaid liens again. And these only apply for people who are in long-term care for at least 6 months. They don't apply until after the person is in long-term care for at least 6 months. And then there are exceptions to every rule, so this would be something where there would potentially be an exception to also. Then here is a time where you could demonstrate medically. You may be asked to demonstrate that you can go home. The home may be exempt, but there may be the possibility of a lien against it. So Medicaid liens are back. Also trusts. Generally trusts are countable. There are some trusts that are specifically exempt. For example, if you have someone who's a young person especially, and they get some money and you can put that into a trust for them using Medicaid rules and certain provisions that we can use around Medicaid qualifying trust. We're not going to get into all the specifics of that either. And we're also not going to get into the specifics of annuities and other trust-like instruments, as we like to call them, because they get it gets kind of complicated. Okay, she said we have 15 minutes left, so I think we're going to do good. Okay, so I want to talk about estate recovery. Estate recovery is something that sometimes is very fearful to folks because estate recovery, it does exactly what it sounds like it does. It recovers from the estate of somebody who is deceased. When you sign on for Medicaid and you sign on for either long-term care or you're age 55 and above, and long-term care doesn't mean HCBS. Long-term care only means institutional care in this situation. So HCBSers who are under 55, estate recovery doesn't apply. So age 55 and above or institutional care, we will recover after death any amount of money that we pay out if that's left in your estate. So your estate would be subject to recovery estate at the time of death. We can recover the amount of medical assistance that we pay out. It's also not applicable to Medicare savings programs or our family medical programs, but it is applicable to people age 55 and older and any institutional care that you get. There are some exceptions. The exception would be if you have a minor child or a disabled child, we're not going to recover then. You're completely exempt from estate recovery. Thought is then those assets would go to those individuals. And if you have a spouse, recovery is delayed until that spouse also passes away. And at that time, we would recover from the spouse's estate. So if the spouse, so an example of that might be if you have that, let's go back to a couple that we had before, like Fred and Ethel, where, after Ethel may have passed away, and she may have had, maybe we paid out $100,000 in medical claims for Ethel. Well, we're not going to recover from Ethel's estate, but then 3 years later, when Fred passes, then we would go after Fred's estate at that time. Then Fred's estate would be subject to recovery. So up to the max of 100,000. So if Fred had, hit a windfall in there and his estate was worth $500,000, we wouldn't take the full $500,000. We would only, we would have a standard claim. And we do have a first class claim too, so that's something to remember. Estate recovery prepayments. I want to talk about that for just a second, and that's something that our clients sometimes like to do. What will happen sometimes is that maybe they'll sell their house. This is actually fairly common where you'll have somebody who will sell their house and they don't want to go off of Medicaid. Maybe they don't want to lose their HCBS slot, or maybe they don't want to deal with just the hassle of Medicaid. So they'll say, what can I do? And you'll say, well, let's prepay estate recovery. You can actually, we'll take checks. We actually take money ahead of time as a way to kind of pay into that estate. So that reduces your estate recovery claim at the time of death. So maybe maybe you have something else, maybe there's a life insurance policy, you're keeping a term life insurance policy going, and you want some of that money to go to your children or something. That would reduce the amount of money that we would have in your estate recovery claim through those prepayments. But most people, quite frankly, use that as more of a convenience thing. Like I said, and then sometimes we see people do that, like with HCBS. If they come across the money and they don't lose that HCBS slot, then they will go ahead and do the prepayment option if they're over 55. The other thing I wanted to point out is something I bet not very many people know about, and that's that long-term care partnership program. So if we can talk about this, this is actually a way to reduce and eliminate sometimes your estate recovery claim. And this is a program we started, I want to say about 5 years ago. And we were talking today in the office right before this, if we had seen anyone who had taken advantage of this, and I don't know that we have. And it really is pretty cool. So what this is, it's a way that qualified long-term care insurance payments. So if you have a qualified long-term care insurance and it pays on some of your coverage, it actually pays out, you get a benefit. We call it on the front end and on the back end. So that resource limit that we talked about before will actually increase the resource limit, and we actually reduce your estate recovery claim. That applies to anyone who is single or married couples. So it would basically say any long-term care insurance payments that we pay out, and the example is out there, so if we have a long-term care plan that pays out $20,000, your resource limit to qualify for Medicaid is then $22,000. But then also your estate recovery claim is reduced by $20,000. And that is something that, like I said, we don't see a lot of people take advantage of. To qualify, it does have to be what they call a qualified long-term care insurance plan. And at the time, the last we checked, most of the plans being sold in Kansas were qualified long-term care insurance plans. But it is something to look at and something to make sure that when we're asking people, if you've ever had long-term care insurance, if you've ever had that, and if it's ever paid anything, because this could be something that they have that they may be missing out on. One thing that we do not have with this either, and that we're still working on, is reciprocal agreements with other states. So that's something that we don't have in place yet. We always thought that, if we saw people starting to take advantage of that we would do some type of reciprocity agreements with like Missouri and Nebraska and such. But right now, these are just Kansas plans, but something that we may look at in the future too, and something we actually have the authority to do. So, one last word about estate planning, and I want to just, we determine eligibility. We don't give estate planning advice. So our mode of operation on this is that we will provide a determination once an application and documentation is provided, that if estate planners call us, if estate planners contact eligibility workers and say, hey, I want to get my person qualified for Medicaid, we're not into giving that type of advice. We will certainly help people understand what the rules are. Most people aren't trying to trick the system. They're just folks who need coverage, they need medical care, they need long-term care. But we do see this often enough that we've actually come out and said that we don't give that type of advice. If that's something that you want to do, if you have a question about how we treat a document or how we would treat a transaction, send it on in and we'll make a determination. Of course, so we will still help people, talk about resources, accountable assets, but hey, what would happen if I transferred $500,000? Do you think I should do that? That's what we're going to say. We don't give estate planning advice. So anyway, I think that's all of the presentation, and I think we have just a couple of minutes left for questions. If anybody did have any questions about spousal or resources. Yes. Yes, income producing property and rental property are both exempt. Yeah, rental property, as long as it's producing income consistent with its value. So again, that would be the real test, is that it would have to be producing some type of income, but rental property is certainly included in that. Yes, you have a question?
Can you explain the special portions that have to be in the long-term care of 30 consecutive days? And then does term insurance have anything to do with term life insurance?
Term life insurance is generally, there is no cash value. It's usually once you stop making payments, you don't have it anymore. So there is you're not accumulating any value to that. It's only a value.
Like it's Spousal Impoverishment, you have $100,000 life insurance term, you leave that to your husband or your spouse.
Yeah.
Would that be a problem with the spouse?
No, because there is no cash value. We usually don't count it. It's only cash value, whole life policies that would have a cash value. And then your other question was to explain that 30 consecutive days. So what that basically means is someone who, 30 consecutive, any long-term care, we consider any time you're in an institution. So think about it in any type of institution, a hospital, a rehab, a nursing home. Those are the kinds of facilities that we're talking about, if that's 30 consecutive days. So maybe you start out in the hospital. Maybe you had a fall and you went into the hospital for a while. And then you're in the hospital for a week, and then maybe you went to rehab for a week. And then maybe you went to the nursing home for maybe just 2 to 3 weeks. If that hits 30 days, then that's 30 consecutive days of long-term care. And that's where that picture, that snapshot of your assets, that starts, and that's considered your month of entrance in long-term care. So it's whenever that is, even if you go back home, that starts that time when we're actually going to look at that spousal impoverishment assessment, take that snapshot of those assets.
So if you apply for spousal impoverishment 2 years from then, they go back to that?
Yeah, we'll always go back to that time. Yes. Yeah, and you had a question?
Just to say, to clarify, so that amount of money that you're going to divide in half is from 2 years?
Yes. Good or bad. So we've seen cases where sometimes people will actually gain assets, and then they'll, because that spousal impoverishment, it's kind of the you got to think of it opposite of Medicaid, because you want your assets to be really, really high for that assessment. So when you divide it by half, it can be as large as possible, because dividing 400,000 is better than dividing 100,000, because then you get to keep more. So if people have actually gained assets, then they're disappointed. But if people have lost assets, and usually that's what happens, is our assets usually dwindle, then it's usually better to go back. Now, sometimes we do see people do things like sell their homes and stuff like that. So it can be, said, but it is good or bad. It's whatever was in place at that time. Now we will use, because that amount, the 23,000 and 119, those figures change every year. So we'll use whatever figure is in place at the time we're doing the work. So if we did the work today, we would use current figures, even though we're looking at a date 2 years ago. Okay, I think we have just a couple of minutes. Yes.
To do the separation of assets, do you have to, do you do that? Do they do that in the local DCF offices?
Yeah.
You don't have to have an attorney?
No, you don't have to have an attorney, but if they want one, they're certainly welcome to it. We're certainly not going to discourage anyone who wants to do that, but you definitely do not. And again, remember, all this is just a paper. It's just a paper thing where we're writing assets down. There is no separation. There is no division until we actually take names off. So up until then, you're just adding everything Fred owns, everything Ethel owns, and everything Fred and Ethel own together, and we add it all up. So, yeah, and the DCF office does that currently, yes.
So if you apply for spousal impoverishment, you have to have a
there any other questions? Because I think we are just right at time. Oh, one more. I did have, yeah, there's a handout right up here if you didn't get it. We actually have a few extra, so you guys are welcome, please do take them all back. They were hard enough to produce because our copy machine was going wild this morning, and so it was actually good to get any. Well, thank you very much.